A very warm welcome to our podcast series. I am Gaurav, and in this podcast, we shall embark on a journey where technology, as it intersects with the complex and ever evolving field of law. In this section, I will be talking to my colleagues here at Fox Mandal and Associates to unpack the bracing questions of our times: how technology is navigating India's new criminal laws. So let's begin. I have with me my colleague Saurabh Bindal for joining us from the Delhi office. Saurabh, a quick introduction of yours by yourself, and then we can get down to the right questions.
Thank you, Gaurav, for inviting me to the platform. I take care of disputes and litigation practice in Delhi for our firm. I have also authored a couple of books on different areas of law. So that's a brief introduction. I don't want to give a Nobel Prize to myself.
That was quite humble of you, Saurabh. Just to initiate our discussion, the recent advancement and amendments to law, what, according to you, are the new crime that can be relatively identified under the new regime with respect to technology and law?
So, Gaurav, like everyone is aware that we have now replaced the erstwhile Indian Penal Code, which we had from 1860, with the Bhartiya Nyaya Sanhita. Now, there are certain provisions to talk about intersection of technology and how that intersection might lead to creating an offense. Like, for reason, when you talk about stalking, which was section 354D in the erstwhile IPC, that used to talk about online stalking. Today as well, when you read section 78, that online stalking is still exists. So, there are no changes to this very provision. So we have, when we amended in 2013 the IPC, when there were some amendments in the criminal laws, we had made sure that the word, online or electronic communication or electronic records come in. The Bhartiya Nyaya Sanhita talks about it more elaborate sense where it has kept those aspects where technology was intersecting with certain acts. It has also included certain categories of offenses, like spreading of false misinformation. That has been categorized as one of the offenses under Section 353. It says that even if you're using electronic means and you want to spread a false information, that'll be an offense. So what I want to tell you is that there are two categorizations. One, where you talk about an erstwhile IPC provision, which talks about intersection of technology with certain acts which might lead to an offense. Those provisions have been kept as it is. The section numbering has been changed. The other category of provisions or sections are where they've included intersection of technology. Maybe there are sections of promoting disharmony between different religions. In that section, the word electronic communication or communication through electronic records was missing. That has been put. So when you look at the entire Sanhita, because we are talking about Bhartiya Nyaya Sanhita, that Sanhita majorly has been evolved so that with changing times, we are up to speed.
I completely concur to what you say, Saurabh. You see, with the recent happenings in Kenya, Nigeria, Bangladesh, and UK, where all these information being spread online and fake news. So, while addressing acts that endanger India's sovereignty, unity, and integrity, how inclusion of an electronic communication in the definition of sedition affects online discourse and digital activism, as per you?
Very interesting question, Gaurav. So, when the sedition law came, that sedition law came in 18, IPC is 1860, 1870, sedition law was brought. India was still a colonial state. The Britishers were not, allowing India to grow. They wanted to quell all the protests which might have gone against their government. That is why sedition was brought. At that point of time, the sedition law used to say that anything which is going to be a disaffection against the government, that will classify as sedition. Now, there were debates, there were judgments by the Privy Council, like there was a judgment by, which is Queen versus Bal Gangadhar Tilak, where the question was, what is disaffection? At that point of time, the court said that, disaffection is nothing but disloyalty against the government. And it differentiated disaffection with disapprobation. It said that, if you are commenting on the activities of the government, which is not going to affect the functioning of the government, that will fall under the category of disapprobation. After this distinction was made way back in 1870s, the other milestone came where, the IPC was again amended, and there were three explanations which were added to Section 124A, which is the erstwhile law of sedition. Those explanations, talked about what is disaffection, what would amount to disapprobation. Subsequently, these provisions were challenged. There were different judgments. There's a Kedarnath judgment. There's a Varundua judgment where the constitutionality of Section 124A was challenged. The Honorable Court has always upheld that. However, in our Bhartiya Nyaya Sanhita, very interestingly, the term sedition is removed. So they have included this exactly. They have captured the term in Section 152. The entire provision of Sedition 124A has been captured in 152. And this same very provision talks about how, communicating electronically can also lead to sedition, which might, challenge the sovereignty and integrity of India. Like you said, there are all news items everywhere from Bangladesh, Kenya. You see, there's a lot of things which are happening against the government. Today, we are moving in a digital age. So when we are talking about AI, we are one step ahead of, the digital age, I must say. We are not moving towards digital age, we are moving towards AI. Today, in this scenario, use of the terms like electronic communication becomes more necessary. So when I see this revamp, I must say it's a revamp of what the old sedition law was. I see that there was a need to bring this term. Because, today the governments are very fragile. We are sitting in a democracy, but the governments are very fragile. So to make sure that the government works as per what the law of the land is, and the people obey the law of the land, I think this kind of addition of the term electronic communication in the offense of sedition, which is now Section 152, becomes all the more essential.
That's a very important observation here, Saurabh, because as you correctly pointed out, these laws were enacted during the colonial era. Now, having come out of those fallbacks, in India, we face a sensitivity towards religious harmony, right? Now, given the circumstances, how electronic media is under the scanner now, and how communication on the tech platform also is under scanner. So, with respect to the freedom of speech and expression, how do you see it intersecting under the new laws?
See, like it is said that every law is deemed to be constitutional. When you talk about any law, for that reason, Bhartiya Nyaya Sanhita, I have to go by the assumption that it is constitutional. I do not see violation of freedom and speech and expression. Freedom of speech and expression under Article 19(1)(a) comes with a rider, which is Article 19(2). It says that there can be reasonable restrictions when it comes to the integrity or security or sovereignty of India.
Absolutely.
So when you read that rider and when those restrictions are reasonable, I do not see, on that touchstone, this law being challenged. When it
Now,
comes to
as you,
sedition or when it comes to the Section 152 in particular, I see a lot of, restraints that have been put in those sections. There's an explanation given that what might not be considered as an act of sedition. So when it is not a straitjacket formula that somebody writes an email against the government, that will be called a sedition. Of course, then that cannot be called.
True.
So that being the case, when there are safeguards involved, when there are reasonable restrictions, I do not see these kind of provisions in the entire Bhartiya Nyaya Sanhita being challenged.
So, Saurabh, taking this cue further from harmony between the different sects within the country, we also see that this is subject to some organized crime, right? Which religious harmony is one part of the segment of the organized crime. So, from that organized crime perspective, how do you see technology playing a role in both facilitating as well as combating crime?
So, Gaurav, another interesting question. Organized crime is something which has been introduced in this Bhartiya Nyaya Sanhita. I have not read this term in the IPC, as well IPC. So it's a new terminology. Section 11111 talks about what is organized crime, and 112 talks about what are petty organized crimes. Now, when you talk about technology and the section of organized crimes, it says that if there's an organized syndicate which is doing a continuing unlawful activity, they have defined what is the term organized syndicate. They have defined what is the term continuous unlawful activity, which includes, it can be anything, which includes robbery, which includes maybe theft, which includes economic offense, cyber crimes. These all will be covered under the definition of organized crimes. It says people who are involved, they will be held liable, even if the act is not committed. So what? Whoever helps them is also liable. So it's a very broad definition, but it talks about what is economic offense, what is cyber crime. So if there are 5 or 6 people who are involved in cyber crime and it's a cognizable offense, then in that case it falls under the definition of continuing unlawful activity, and that will be taken under the ambit of organized crime. There are different punishments which have been labeled against in this section. So it's a very new section. How does it operate? We have to see. But I see that because in today's world, what is happening is that somebody is sitting in Jamtara, somebody sitting in Delhi, somebody sitting at some other place is coordinating amongst themselves, and they are able to take out money from Saurabh Bindal's account. This is nothing but an example of organized crime which is happening these days. Related to that, the government has put in this definition of organized crime in the Bhartiya Nyaya Sanhita. I welcome this move because it's a very good move. So that we can curb these kind of acts in future.
So I think one of the biggest areas of concern for any governance or a governing body would be to curb a situation of spread of misinformation or fake news, right? And that also falls part within the ambit of the larger organized crime. So what would be, according to you, the main objective behind criminalizing the dissemination of false and misleading information? And also would also like to have your comments on how can we balance the need to combat fake news as well as protecting the rights of the individual.
See, Gaurav, I see a lot of fake news being circulated on different medias. We are all part of different WhatsApp group where people are spreading whatever is coming to them.
Correct.
This is nothing but spreading fake news. See, I always tell people that population which India has is always a boon, and it is also a bane. With so many people having handset, it's good that we are using technology at such a vast pace. However, so fake news is great. It can defeat a government. Like we are seeing example in our neighboring countries. People maybe by using fake news. I'm not there, so I can't comment. But what is happening is with fake news, they are able to topple the government. They are able to promote disharmony between different classes, between different religions. To curb that menace, I think that is the reason that the government brought in Section 353, which talks about spreading of fake news, which is going to, and I'll try to read some provision, some very specific lines for it. It says 353 clearly puts in that whoever makes, publishes, circulates any statement or report containing false information, rumor, including through electronic means, with an intent to create or promote, or which is likely to create or promote on the grounds of religion, race, place, birth, residence, language, caste, community, or any other ground whatsoever, feelings of hatred or ill will between different people will amount to an act of offense under this particular section. So to curb all this, it is a welcome move, I suppose, which the government has brought. There's one more insertion which they have done, which is not under 353, which falls under section 197, which talks about, which is a subset of how to promote religious harmony. This categorically in one of the subsets. So this was not there in IPC, but it says whoever by way of word, spoken, written, or visual representation through electronic communication makes or publishes false or misleading information,
Mm-hmm.
jeopardizing the sovereignty, unity, and integrity or security of India, will be
Mm-hmm.
punishable. So it's a very wide ambit which
Mm-hmm.
Section 197 creates now.
Mm-hmm.
The erstwhile section was 153B. 153B was not having this particular line which I've read.
Mm-hmm.
It had all the three sub clauses, but this clause was missing.
Mm-hmm.
So the government wants to go heavily against people who are spreading fake news,
Mm-hmm.
which is going to challenge the
Mm-hmm.
integrity of this nation.
Absolutely. So, yeah, in fact, one of the discussion points also from these fake news and as well as with respect to organized crime is also the question of forgery. How do you think the legal system can effectively determine intent in involving electronic forgery?
So, Gaurav, when it comes to forgery, Section 336 is exact replica of Section 463 of the IPC. 6 talks about forgery and it defines what forgery is. It says if the electronic records are played with so that you can harm the other person, damage or injure the other
Mhm.
person, then in that case that would amount to forgery. So this term, which is nothing but electronic record or forging that electronic record, was already present in the IPC.
Mhm.
I do not see much change in this. But I understand why this is necessary because everything is now becoming electronic. We all are using somehow the digi lockers. We
Mhm.
are putting our data electronically. Somehow, if somebody uses or manipulates them and forges that document and moves ahead or maybe harms or damages or injures some other person, definitely, as per this section, they will fall as a person who has committed crime.
Mhm.
So this is not a new section. This section was there. The term was there.
Mhm.
There's nothing new in this. It's just that the section number has been reshuffled.
Right. Yeah, that was quite an insightful discussion with you here, Saurabh. And to sum up, yeah, I think one of the basic ingredients that we need to, as citizens, need to identify is that before you spread any information or share information, it is always prudent to verify the information, as you also pointed out. And similarly, I think it is lot left to the prudence of as well as the intelligence of the masses as well as the citizen of the country to ensure not to be on the wrong side of law, right?
Certainly.
Yeah, thank you so much, Saurabh, and it was a very insightful session. And to our listeners, I hope you audience found this discussion insightful and thought provoking. Technology and law are constantly evolving, and staying informed is the key to navigate this dynamic landscape. Until next time, keep questioning, keep learning, and keep exploring. And in short, stay curious. Thank you.
Thank you.
Thank you.